Hello and welcome to part 2 of the 36 Family Introduction to Family Law of England and Wales. My name is Marisa Allman. I'm a barrister with 36 Family, specialising in family law. I practice in both financial and children matters, and I'm also an arbitrator and a fellow of the IAFL. Today, in part 2 of this webinar, I'm going to be talking about the process of divorce and dissolution, also conflict of laws and what happens when there are several jurisdictions or more than one jurisdiction available, and how we go about looking at the question of what jurisdiction you should issue in when you're advising a client with a number of options. So first, to talk about divorce in England and Wales. In 2020, the Divorce, Dissolution and Separation Act was given royal assent and it came into force in 2022. This represented a seismic change in the divorce process of England and Wales, in particular that it resulted in the sole ground of divorce being irretrievable breakdown of the marriage. No longer did either party wishing to have a divorce have to prove adultery or bad behaviour, desertion or indeed separation. It also removed the possibility effectively of contesting a divorce or objecting to being a divorce, and as a result of those changes, realistically the only way in which a party can oppose a divorce being granted in England and Wales now is if they dispute the jurisdiction of the court in England and Wales to grant a divorce. For example, if they dispute the jurisdictional grounds, if they dispute the validity of the marriage or the civil partnership, or if they assert that the marriage or the civil partnership has already been legally ended in another jurisdiction. It remains the case that spouses must have had to be married for at least a year before they can obtain a divorce or dissolution in England and Wales. But after that, it's now a relatively straightforward online procedure where a party solely or the spouses together can make a joint application for divorce, and the sole ground, as I say, is just irretrievable breakdown of the marriage or of the civil partnership. They don't have to produce any evidence that the marriage is broken down, and the other party is not able to dispute whether it has broken down or not. Thereafter, there's then a waiting period of 20 weeks before what is called a conditional order can be granted. That's a sort of semi-divorce, if you will. And after that, then there's a further 6 weeks before a party can make an application for a final order of divorce. One thing that you may find different in England and Wales to the jurisdiction that you practice in is that when an application for divorce is issued, that only deals with the marriage of the parties and their divorce. It does not deal with any matters in relation to children, and it doesn't trigger any proceedings in relation to children. As my colleague Andrzej Bajarski said in part 1 of this webinar, very often children proceedings are dealt with by an entirely separate judge in an entirely separate court. I'm going to talk a little bit about what we mean by marriage and civil partnership in the context of the law of England and Wales. The Marriage Same-Sex Couples Act 2013 allowed same-sex couples to marry in England and Wales, and similar provision has also been made in Scotland and Northern Ireland. Prior to that, the Civil Partnership Act brought in civil partnerships for same-sex couples in the UK, and this was later amended in 2019 to allow opposite-sex couples in England and Wales to also register as civil partners. It's also possible to convert a same-sex civil partnership formed in the UK into a marriage. Same-sex marriages formed abroad are recognised as marriages in the UK, and most foreign non-marital unions are automatically recognised as civil partnerships in UK law. You may have a type of registration in your country of a non-marital union that is similar to the civil partnership that we have here, or called something different, but that will usually be recognised as a civil partnership in England and Wales. And so it's possible in the law of England and Wales to have a same-sex married couple, an opposite-sex married couple, a same-sex civil partnership, an opposite-sex civil partnership. The jurisdiction to terminate a civil partnership or same-sex marriage is exactly on the same basis as marriage generally. Additionally, where a civil partnership or same-sex marriage was formed in England and Wales, our courts will also have the jurisdiction to terminate that union if no other country accepts jurisdiction. That avoids a situation where people who have entered into a same-sex marriage or civil partnership are unable to get divorced or have their civil partnership dissolved. In England and Wales, civil partners enjoy exactly the same rights and responsibilities as married couples, and the status of civil partnership and marriage are distinct but equal. All of the rights of the marriage or civil partnership under English law will apply regardless of any limitation applied by the country where the couple got married or entered into their civil partnership. That might mean that if you have clients who formed a civil partnership in a country where their rights were limited by reason of that being a civil partnership rather than a marriage, and they then divorce in England and Wales, they will be afforded greater rights on divorce in England and Wales than they might have been in the country where they entered into that union. That's something for you to be aware of. Cohabiting couples are in a very different position in English law. We don't have any umbrella legislation that deals with the financial consequences of the breakdown of a cohabiting relationship. We don't have a principle of a de facto partnership in the same way that some jurisdictions do, and property rights are dealt with really under trusts law when it comes to cohabiting couples. English trusts law means that it's possible for a person to have a beneficial interest in a property which they are not the legal owner of. This can be as much as 100% of the property, and the courts have the power under the Trusts of Land and Appointment of Trustees Act 1996 to determine whether a person has a beneficial interest in a property, and if so, how much. A trust can be established by a deed of trust, but it can also be established in other ways that don't require a deed or other document to establish the trust. There might be an express verbal agreement, or an agreement can be inferred by the court, commonly from the claimant making a direct financial contribution to acquiring a property or to making improvements or renovations to a property. A beneficial interest in property can also arise through a concept called proprietary estoppel. This means where one person makes a promise to another that they will have an interest in a property, or leads them to believe that they will have an interest in a property, and the other person relies on this promise or representation to their detriment. What this means for you and your clients is that if you are representing somebody who is not married, but perhaps lived with their partner in a property in England and Wales, owned in the partner's name, or put money into a property that was owned in their partner's name, it's always worth taking advice about whether your client may in fact have a beneficial interest in that property under English trusts law, even if that is not a property to which they hold any legal title. A brief word about inheritance. In English law, testators are generally free to leave their estate as a wish. However, if a person dies domiciled in England and Wales, a person can make a claim on the estate if they are a spouse, a civil partner, an ex-spouse, an ex-civil partner, or a cohabitant who has lived with the deceased for up to 2 years before their death, children, stepchildren treated as deceased by the deceased as a child of the family, or financial dependents of the deceased. Except in the cases of spouses and civil partners, claims are limited to reasonable provision for maintenance, which might include housing as well as income needs. Again, for your clients, if your client has been in that sort of relationship with somebody who may have been domiciled in England and Wales, then it's worth you taking advice about whether they might have a claim in relation to that person's estate in the event of their death. One of the most frequent areas that we as barristers are asked to advise about is whether the courts of England and Wales has jurisdiction to enter into a divorce or a dissolution. The grounds for divorce and dissolution in England and Wales broadly mirror those which are set out in the EU regulations of 2019-1111. Those are governed by the Domicile and Matrimonial Proceedings Act in England and Wales. And those are that both parties to the marriage are habitually resident in England and Wales, or they were last habitually resident in England and Wales and one of them continues to reside there. If the respondent is habitually resident in England and Wales, if there's a joint application, either of the parties is habitually resident in England and Wales, or if the applicant is habitually resident in England and Wales and has resided there for at least a year immediately before the application was made, or the applicant is just domiciled and habitually resident in England and Wales and has resided there for at least 6 months before the application was made, both parties are domiciled in England and Wales, or either of the parties of the marriage is domiciled in England and Wales. This might mean, for example, that you would need specific advice about whether your client or the other party might be domiciled in England and Wales under the laws of England and Wales. There might be a number of jurisdictional bases that you might want to consider with your client, and that might include, for example, whether your client should move to live in England and Wales for a period of time in order to found the jurisdictional basis for divorce. As you will know as family lawyers, it's often the case that there is more than one country having jurisdiction to entertain a divorce or dissolution. Where England and Wales has jurisdiction in the divorce, it also has jurisdiction to determine the finances on divorce. For those of you that practice in EU member states, you'll be familiar with the EU regulations which provide for what is to happen when more than one member state has jurisdiction. In situations where proceedings were issued before the 31st of January 2020, according to the withdrawal agreement, then those laws will still apply as to disputes between England and Wales or the rest of the UK and other member states. For proceedings issued after that time, then there is no lependen rule. There is no rule, as far as English law is concerned, that the state which has first in time been issued with the divorce proceedings should prevail, and the position reverts to a situation where the question of which country should deal with the divorce falls within the Forum Convenien rule and the provisions of the Domicile and Matrimonial Proceedings Act 1973. When parties issue a divorce in England and Wales, they have to declare whether they know about the existence of proceedings in any other country. The court needs to then go on and consider the balance of fairness, including the balance of convenience as between the parties, in order to decide in which country the proceedings ought to take place. The court has to look at all of the circumstances of the case, but particular weight is given to the connection that the parties have to each competing jurisdiction, where the parties' assets are located, and which court state is best placed to dispose of proceedings fairly and efficiently. This might include factors such as where the key witnesses are located, where the evidence is located, what language the parties speak, and what language the documents are in. The English court can decide that the English proceedings prevail, but you will know that that doesn't act as a stay on proceedings which may be going on in the jurisdiction in which you practice. It is important for you to know as a practitioner in another jurisdiction, however, that the English court can make what is called an anti-suit injunction or a humane injunction against any party in the proceedings in England and Wales to prevent them from pursuing proceedings in another jurisdiction. That is something that you may wish to take advice about if you find yourself in that situation. Another area that we're often asked to advise about as family lawyers is whether a marriage or civil partnership entered into in another country is recognised in England and Wales, or whether a divorce obtained in another country is recognised in England and Wales. A marriage celebrated in the form required by the local laws of the country where it's celebrated will generally be a valid marriage in England and Wales, and this includes same-sex marriages. In terms of civil partnership, a civil partnership will generally be valid if it is registered in a country outside the UK in accordance with the laws of that country. Some registered overseas partnerships can be treated as a civil partnership under the Civil Partnership Act, even if they don't exactly fall into that definition in the country where they were celebrated. The court can make a declaration about them, status of a marriage or a civil partnership, which I'll deal with in a bit more detail in a moment. In terms of recognition of foreign divorces, where the divorce or dissolution or annulment or judicial separation of a marriage or civil partnership has occurred by means of proceedings in another jurisdiction, it will be recognised if it's effective under the law where it was obtained, and if at the relevant date either party to the marriage or civil partnership was habitually resident in or domiciled or a national law of that country. Where the divorce or dissolution or annulment or judicial separation was obtained by a means that did not involve proceedings, then it will only be recognised in England and Wales when neither party was habitually resident in England and Wales in the 12 months prior to that date, and either or both of the parties were domiciled in the country where it took place, or if one party was domiciled there and the other party was domiciled in a country where the divorce or dissolution or annulment was recognised as valid. So there are a number of situations which may arise where a party needs a declaration as to marital status. A party might issue an application for a divorce here, and the other party might assert that they were never married, or that their marriage wasn't valid, or that they're already divorced, for example. The court may also make declarations of marital status for other purposes, for example inheritance and the question of whether somebody was the spouse of a deceased under a will. Applications can be made to the court pursuant to the Family Law Act for declarations as to marital status. This includes declarations as to marital status relating to a marriage or divorce entered into in another jurisdiction. So the courts of England and Wales can make a declaration as to whether a marriage or divorce entered into in the country in which you practice, in which your clients live, is valid for the purposes of obtaining a divorce in England and Wales. The particular types of declarations that a court can make are a declaration that the marriage was at its inception a valid marriage, or a declaration that the marriage subsisted on a date specified in the application, a declaration that the marriage did not subsist on a date specified, a declaration as to the validity of a divorce, annulment or legal separation obtained in any country outside England and Wales, or a declaration as to the validity of divorce or annulment or legal separation is not entitled to recognition in England and Wales. This can include questions such as whether the marriage was void or voidable, or indeed not a marriage at all. Both void and voidable marriages can be annulled. That includes, for example, in circumstances of bigamy, and still give rise to the court being in a position to make financial orders. And that may be something that you need specific advice about. So there are a lot of factors to consider when giving advice about forum, and this is one of the reasons that it's important to take advice in all of the jurisdictions which might be concerned. There's the question of the range of likely outcomes in each jurisdiction, how well your client is likely to succeed on particular issues, how a court is likely to approach a specific issue. For those of you who practice in a jurisdiction, for example, where the question of adultery might substantially affect the outcome, it's worth knowing that in England and Wales that's not a factor that would influence the court one way or another in deciding a financial remedy. You may need advice about the implications of the location of a property or business or pension, or about enforcement in particular. You would also need to take into account the English approach to issues of forum conveniens, and if there are competing jurisdictions, how the court will be likely to decide which jurisdiction should proceed to deal with the divorce or dissolution. And crucially, it's important to take advice about the Matrimonial and Family Proceedings Act 1984 and the availability of remedies under that act, which, as Andrzej Bajarski said in part 1 of this application, is available in circumstances following an overseas divorce. And that is the topic that my colleague, Mr. Paul Infield, is going to be talking about in part 3 of this webinar.